All right, let's begin video 4, post-Norman invasion, the beginning of feudalism. Boer-Alaskan writes at the beginning of chapter 1 of Cases and Notes on Land Law, it is said, he states, it is said above that at the time of the conquest, two great river systems of the past joined forces. The cultural inheritances grouped together in the forces of the invading William came to live, and eventually to mingle with the ways of life which had grown in the preceding centuries on the island of Great Britain. Both Maitland and Oxford writings referred to in video 3 agree that both systems pre-AD 1066 interwoven themselves into the tapestry of the eventual right to rule under the Normans, which was referred in past videos as being still in force today, but hidden by means of capturing the collective educational system to which we all become accustomed. We do not even see the history and how everything has all evolved. Maitland highlights this transition and using the interpretation of AI, whereby AI writes, Maitland was discussing in his writings the importance of local customs, resilience, even under growing monarchical influence, suggesting that some tribal practices persisted alongside formal legal developments longer than others suggest. And you'll see a little bit further on in this video where it actually will make a reference to what had just been mentioned. Returning to Boer-Alaskan's book, he writes, as William exploited the gains of his military victory, substantial quantities of land came within his power of disposition. The Saxon king, and I'll insert here that would be King Harold, and many of the important Saxon landholders died at Hastings. Successive efforts at rebellion against the spreading lava flow of Norman power resulted in further Saxon deaths. The lands formerly dominated by the Saxon king and by his henchmen became forfeited, and William, with his group, could designate good Normans to step into the vacated positions of land control, unquote. The majority, consisting of peasantry and outlying tribal systems, were most likely unaware of the takeover by the new Norman overlord, and in much the same fashion as today, they unwillingly climatized to the business as usual scheme, which is basically to keep your head down and for fear of any reprimand. The basis of this happening is against the rights of men, obviously. Anybody that comes in and takes over your land without or against your will is obviously not lawful. But is it against the rights of men who want to secure a piece of land for themselves, their families, and allies? So gleaning, essentially, the prospect of security from any would-be invaders who are also wanting the same. Today we know that if someone attempts to usurp our right to property, we can bring their bodies to court so as to answer for this crime. Yet, if the government proceeds against your property, now I just want to inject here something to keep at the forefront of your thoughts, and that is to always keep in mind of the words that I try to use, because they need to be qualified each time, and they will be qualified over time of why I use certain words, or try to. I can overreach by not paying attention as well, but I try to do my best at this. Now, I'm not speaking to the land or the soil, namely, or specifically a common law estate inland when I said a right to property. A right to property is a different right, another type of lesser estate in land disguised as a superior right to those holding an estate interest prior to 1925. A right of property is a legal right, not an equitable right, so as to control a piece of land under the concept of having complete ownership by making it enforceable against all the world. This new title, and so according to this right, is an ownership of a right, but never a allodial right to the land itself. Now let me return how I started this paragraph. Yet if government proceeds against a property owner, isn't the concept of eminent domain being the overreaching rule, disguised as for the benefit of the individual who holds the property, underpinned as for the benefit of the singular personality, that personality cultivated by a group such as a country or corporation? Basically, isn't them protecting your security of that property the reasons why they got to usurp your land under the guise of eminent domain, so that it could protect that security for the interests of all others who have agreed to it. Okay? I mean, we see it so clearly being played out through the pre-planned Hegelian dialectics that began after 1925, and the land and property rights which emerged through acts, and which is still clandestinely assimilated through the Property Act only by means of the events that happened in 1929, and more recently being more pronounced in 2001, 2008, and 2020. Again, this all is starting to, as a cattle are run through a chute, we, through these events, are automatically unwittingly be ran through a certain chute in order to meet the desired end of law and property acts. Okay? And we'll get into that. You'll get to know that if you haven't already gone through my previous series. But you'll start to realize that, hey, we're just following what the law has already prescribed. And again, it's only based on our own ignorance of what that is. The benefit of the group dynamic is front and center always, culminating from a pivotal period in law, which runs in contradistinction to the mental and physical well-being of each individual, which otherwise emphasizes upon security of rights belonging to each individual, a being of nature, and as a class of humanoid. The social contract becomes the overriding feature, which covers that rock, identifying the human unalienable rights. Our agreements are our own nemesis. Unchecked, they unwillingly manifest into our reality, unimpeded by our trust in the tailored narrative of the time, all under the guise of the illusion of security. Are we so much different than the time of the 11th century and the conquest by the Normans? Borlaug draws the similarity of a conquest done by nobility, those of the archaic feuding bloodlines, or most often sibling rivalries concerning their right to claim to rule. And now we classify it as a settled system of the caste, whereby Borlaug draws into his book the exploits of single men, such as John D. Rockefeller or George Eastman, who worked towards the domination over needed materials and control over the logistics to distribute the finished product by absorption or extermination of their competitors. How different is this to the exploits of William the Conqueror, aka William the Purchaser? It is against the law to impose one's will over another. That we know. But is it against the law to impose one's will's right to profit in a corporation over another will's right to profit and through the guise of a corporation? The clearest or generally accepted definition of natural law is that branch of ethics having to do with human justice, which provides an objective standard for evaluating human actions involving force against other humans. Is today's standards, when measured against our current situations, representative of this controlled time loop, whereby nothing new is under the sun, using the self-interpreted adage, playing within the same mind, that, you know what, history just simply repeats itself. Are you metaphorically holding possession of a new set of glasses which can pierce the illusion, and so begin to interpret that devil existing within the details, whereby all of this, for the time of the Norman conqueror's personality, is in reality that mirror image of today's corporate giants of Vanguard, BlackRock, and Safety Street? Doesn't this provide preponderance of evidence that proves that we are not in law, but merely interacting within something completely different? Law, if not realized already, is for the living to use so as to defend themselves against a group. That personality, that group personality, is determined as a fiction of law, which in itself is not an issue when each individual returns to the law and thus understands what is being conveyed, but mainly innerstands through self-proximity, which is the advance of wisdom, that one can only be affected by the invading force of the group dynamic by not coming into each individual's own power. This power is diluted further to the totality of their own expressed or implied agreements. Today's holding of any land trust is, for greater certainty, an agreement to the rights offered of a lesser estate in land called the property right, evolved through the feudal land tenure system and still running today, which secures an action against all the world who are subject to the same interest by means of the same agreement. What has been carried over in today's present law, so to add credence to the new tapestry formed by the merging of pre-AD 1066 conquest and the new feudal and land tenure system established thereafter, are of three sorts, expressed by Borlaskin. First one he mentioned is land held by book right, so as to identify it against specific laws that secure this interest. Secondly, land of private persons, those spoken as a folk right, and thus expressing fixed terms agreed by a community. And thirdly, the church's land right, that is subject to offering an interest to land for life, in the interest of a life, in return to agreed services, which now rolls into the basis of that every property interest ever held today comes infused with an obligation. What is not made clear in these observations by Borlaskin through his initial address into the history of English law was making a direct connection to land through the device known as inheritance. I mentioned in his video's opening paragraph referred to of Borlaskin's book, which identifies the grouping of cultural inheritance being grouped together with the will of the Norman's strong arm influence. So he mentions inheritances, but doesn't bring it forth into the reader's mind again until much later in the book. Now, and I'm not really 100% sure when I said that I read every page, so how he's addressed it, but he didn't make that correlation at the very beginning. He only mentions cultural inheritances, but you know what? You're going to find out that this whole thing, the evolution of feudal land system and us under the disguise that we're having property rights was because of the advance of people wanting to control land, and that was done through inheritance, willing and divisive. The will, your interest for the benefit of your family, whoever you wanted to, after your death. Now that we have the basis, we continue into video 5 to discuss the type of estates and land interests that were available after AD 1066 and became the features of tenure through subsequent accounting of all land recorded in the Doomsday Book of AD 1066. So that's just want to give you a brief summary of trying to get your head around how we're addressing this whole situation. How that what we do today is just a mirror image of what was happening before. But today, unlike before, through the evolution of the land tenure system, we have now full rights to land, and like we've mentioned before, to that life estate, which we want to find out by the very end of this series. Well, and you may have already reached that point of where to locate that and start now exercising that right to vest that life estate. So I also wanted you to remember just to hit the like button. Of course, as you already know, you've done this many times. The more likes, the more the information gets out, the more it's retrieved within the YouTube dynamic, and then people might come up in their feed as an interest to them based on some of the things that they're looking to investigate. We want full freedom. That's what this thing's about. It's not about trying to acquiesce and trying to maintain some sort of order or some sort of semblance of agreements within the system itself. We are trying to vacate that whole thing altogether and put us back into our proper place. And with that, geez, running a little bit later, 14 minutes. Have yourself a great day.